behalf of Team Sign Up Training, I thank you all for participating in this interactive webinar. That's harassment, discrimination, and the manager's role in workplace investigations. Without any further delay, I'll invite Terry to take over from you. Thank you.
Okay, this is my cue. All right, everybody. Thanks for your patience and thanks for hanging in there, and thanks to our moderator today as well. You can see the agenda on the screen in front of you. I'm sure you saw that when you signed up, and so no reason to go through that. I will say too, one second, please. Oops. I will say too, if you don't have the slides, because they were sent, but sometimes things happen, and they may be in your spam. If they're not in your spam, then they would have went to the email of the person who signed you up, and so check with them. Or if not, you can go ahead and send our moderator a little chat message, and they'll take care of it. So you do not have to write down everything that you see on the screen in front of you. You will get the deck. Okay, so let's just kind of start from the very beginning. I don't really know who you are or what you do or what your industry is or any of that. I do know the workplace is changing and expectations of employers are higher. The standards for what is offensive is lower. Employers are largely better informed. While interestingly, we have a better informed group than we have others who just don't seem to get it that the world has changed. And the fear to speak up is eroding. So this is largely all good in my estimation, that our expectations are higher, and that we're better informed and we'll speak up. I mean, those are all good things, right? Okay, so let's start with an overview. I don't know like I said, I don't know what your level of experience is and how much HR lore you know, but you need a little background to know when we discuss these things, why we're saying certain things are important. So harassment grew as a subset out of discrimination law. And so the first law, federal law, which are the ones we're going to talk about, in regards to discrimination, was a section of the Civil Rights Act. Civil Rights Act of 1964, the broadest sweeping piece of civil rights legislation ever passed. It had different sections in it. The 7th section had to do with employment, and it gave us our 5 original protected classes. And so what it means to be in a protected class is that you can't have adverse employment decisions made about you merely because you possess the attributes of a class that it has been determined that the law is going to protect against having the adverse decisions made about you. So this law made it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. Race, color, religion, national origin, or sex being protected classes. And when they pass a law, when the lawmakers pass a law, they have to give it to an agency whose purpose is to interpret and administer and enforce that particular law. So Title VII created the formation of the EEOC. And so then over time, what happened was harassment grew as a subset out of discrimination law. And the first court case was in regards to sex, that if you're harassed because of your sex, then that would be a form of sex-based discrimination. This is why your discrimination and harassment policies are in the same policy, if you ever wondered why. You're also going to see all the laws that pass across your screen here have language to the effect of the law also makes it illegal to retaliate against a person because the person complained, filed a charge, or participated in any type of employment investigation or lawsuit. Because it wouldn't be much of a protection to not be discriminated or harassed against if when you spoke up, you could be fired or demoted or have something else bad happen to you. Now, just as an aside, every employment law out there has anti-retaliation protections, because all of the leave laws, civil rights laws, equal rights protection laws, workers' comp, all the safety, they call it safety, or they call it whistleblowing instead of retaliation in regards to safety laws. But it wouldn't be much of any type of any employment rights or protections if we could, like I said, be fired or have something bad happen to us because of it. So I'm not going to read all the anti-retaliation language against there. But what you need to realize as a manager is that retaliation, the concept of non-retaliation, is in many respects just as important as the protections of to not discriminate or harass. And they are two separate things. Someone could say that they were paid less than men for doing the same work, and it turns out that that is untrue. But then they're retaliated against. They're not given a promotion merely because of the fact that they complained. And that is a separate circumstance. And so whether or not somebody was retaliated against is not based on the finding of their original complaint. And this anti-retaliation protection extends whether somebody makes an internal complaint or goes to a regulatory agency and makes an external complaint. It even extends to those coworkers who would provide information in the investigation of an employee's complaint. So realize that all the employment laws that protect your employees have anti-retaliation or whistleblower protections, and that retaliation is merely a fancy word for revenge, and whether or not, so it's a separate investigation. If an employee claims they were discriminated against in their pay and it turns out that that's unfounded, then whether or not they were retaliated against is a separate investigation, which its determination, as I said earlier, determination is whether or not they were retaliated against or not, has nothing to do with, in our case, whether they were discriminated against or not. Okay, so it's really important that you understand that. And in fact, if an employee makes a complaint and you don't take it to the powers that be as outlined in your policies and procedures, that can be a form of retaliation. You retaliated against the employee by not taking their complaint forward based on your own company's complaint protocols. Now, the law also requires, this law type, what we call title, you'll hear it called Title VII, requires that an employer reasonably accommodate applicants and employees' sincerely held religious practices, unless doing so would impose an undue hardship on the operation of the employer's business. Okay, so this is all religions, and it doesn't necessarily have to be a religion that you even hear of. In fact, it's considered just sincerely held value principles. And you can be an atheist or an agnostic, and whether or not that religion has tax exempt purposes has nothing whatsoever to do with it, because I can't imagine two federal agencies that have more differing purposes than the EEOC and the IRS. So none of that makes any difference. Sincerely held value systems. And you can't be discriminated against just because you don't want to have any observations on religion at all. Couldn't be discriminated against because of that. And then you can't forget state laws. For example, California, you have a state law in your list of protected classes that has 19 protected classes under the state, and also extends the protections formally to contractors and volunteers and interns, although interns would be employees most of the time anyway, but there are some companies who occasionally have an unpaid intern. So if your contractors in California, for example, people who work for you on a 1099 tax basis, they're protected by the anti-discrimination, anti-harassment laws, the 19 protected classes of California. And when we talk about the Americans with Disabilities Act, California, you have a state law that you don't even have to have a disability, you just have to have a condition. And so state laws will often not only offer employees broader protections, they will affect smaller employers as well. So for example, the state disability law in California, you only have to have 5 employees, where under the federal Americans with Disabilities Act, you have to have 15. All right. The Pregnancy Discrimination Act is actually part of Title VII, and it makes it illegal to discriminate against a woman because of pregnancy, childbirth, or medical conditions related to pregnancy or childbirth. And it's, once again, anti-retaliation as well. So anything related to pregnancy or childbirth, including abortion, and don't forget state laws as